Okay, we'll go on the record in People versus Kelly Davis. This is case number 236584. And counsel, if I could have you and Ms. Davis at the podium there, please. And if you could put your appearances on.
Good morning, Your Honor. John Shirley appearing on behalf of Kelly Davis.
Good morning, Your Honor. For the record, my phone got people.
Thank you. This is the date and time set for a sentencing hearing in this matter. The record should reflect Ms. Davis is present here in the courtroom today. Ms. Davis, have you had a chance to go through the pre-sentence report and talk to your attorney about that?
Yes.
Thank you. And right. Yep. Counsel, are there any additions, deletions, or corrections that need to be made in the report?
Your Honor, just one minor correction to the pre-sentence report at the very bottom of page 7. Her counselor's name is Sherry Peel with a T, not Sherry Peel with a P. Other than that, there are no additions or corrections.
Okay. Court will order that correction be made. Are there any challenges to any of the guidelines that's scored?
No, Your Honor, I believe the scoring is accurate.
Thank you. Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections as to the body of the report other than already noted on the record, which people have no objection to correcting, and no challenges as to the sentencing guideline scoring.
Hoping on behalf of the people for elocution.
Briefly, Judge, this is a single vehicle, one car situation accident, blood alcohol 1617, second felony, second OWL, third, as her prior was as indicated under number 506 from March 16th, 2017, fourth drinking and driving offense since 98. And she has also 2 prior controlled substance offenses. The defendant rolled her minivan on I-75, placing not only herself, but a bunch of others at risk for once again driving while intoxicated. The last time she was sentenced back on May 1st, 2017, she was given 11 months, but only had to serve 15 days up front. This is probably, there's a recommendation of 30 days up front, quite frankly, Your Honor, under the circumstances. That's an awful light sentence, and I think the court should consider sentencing her to an amount of time far in excess of 30 days.
Thank you. Anything on behalf of Ms. Davis today?
Your Honor, Ms. Davis has been in touch with me regularly throughout this process. She's taking it very seriously. She got in her with her counselor right away. She's been working hard in counseling. She really understands the severity. You can tell that she's taking this very seriously. One issue I wanted to point out to the court that may have some impact. She does have some significant medical and psychological issues in her life. Her counselors diagnosed her with traumatic stress disorder. She suffers from psychogenic non-epileptic seizures. She has a neurostimulator in her brain that has a battery that has to be charged regularly. She's on medications, so she is somewhat fragile in terms of her ability to survive in the county jail for any lengthy period of time. We totally understand that for this offense under these circumstances that jail comes with the territory. However, there is that mitigating situation that I would like the court to consider. Her partner Bob Myers is here today. He's very supportive of her. I just ask the court to please show as much leniency as you'll offer. Thank you.
Thank you. Ms. Davis, was there anything you wanted to say today?
I know what I did was wrong, and I shouldn't have did it, but my intent was to take my own life. But I immediately slept on my hotel, and with my clothes, she's opened me to deal with. I have 2 years of trouble. But you know, I didn't understand. I didn't know how to. I was was dumb, I was stupid, and I need to be punished for what I did. I'd be mad if somebody else did that to me. I'm taking responsibility for what I did. Okay. I know why I did it.
Try and take a couple deep breaths, and we'll worry about you. You're very upset right now. So take a couple deep breaths. I read through the report, so I'm familiar with what happened in this case. And there's a lot of information in that report about you and your circumstances and your background as well. This number one, from the standpoint of what happened here, very concerning. Obviously, you could have hurt yourself. You could have hurt somebody else on the road that day. And that's my main concern, is protecting safety of the public so that we don't have you out there driving in this condition where you could cause that kind of harm to yourself or another person. And this isn't your first trip down this road. This is your fourth related offense, alcohol-related driving offense. And you've been on probation a few times, you've been in jail a couple times. At some point, if you don't correct this behavior, you're gonna end up going to prison, regardless of your health problems or your age or anything else, because we're not gonna just keep doing the same thing over and over again. We're gonna need to do something more serious to keep you from engaging in this conduct if you're going to continue to do it. I do think that your health conditions, number one, I think they're legitimate. I'm not questioning that, but I'm sure that using alcohol isn't going to help any of those health conditions that you have. So aside from the public safety standpoint, I think you need to get treatment, get help to the extent that you can't control your use of alcohol, because with these kind of physical conditions, it's only going to make those things worse as well. I do think the recommendation is appropriate. I think it factors in the mitigating circumstances regarding your health conditions. I think it provides the court having you on probation for a period of time. It allows for some supervision to make sure that you're not using alcohol, that you're not operating a vehicle. It's going to hold a significant amount of jail time over your head. And I want you to understand that if you have problems on probation, the health issue is no longer going to be a mitigating factor as far as I'm concerned. So that won't be a reason for me to impose the full amount of jail time later if you have problems on probation. I want to be very clear with you on that. But I think the recommendation here, again, it builds in a degree of punishment up front. It holds a lot of punishment over your head so that there's serious consequences if you don't comply with your probation. But it gives you an opportunity due to your health conditions to avoid a lengthy jail sentence if you are able to comply with probation. And the upside for the community is if you're abiding by your probation, you're not drinking and driving, we're all safer. So I think it factors in all of those different components. And I think it is an appropriate recommendation. So the court is going to place you on probation for a period of 24 months and adopt as the conditions of your probation all the terms and conditions that are listed in the report. Most important of which, of course, is that you not use or possess any alcoholic beverages or other intoxicants. The court is going to require that you serve 30 days up front in Otsego County Jail. The court is going to sentence you to a total amount of 11 months with 30 days up front. The rest to be held in abeyance. You have credit for 7 days served. The crime victim's assessment of $130. Court costs of $325. Supervision fee while you're on probation of $30 per month. A reimbursement fee for the alcohol testing of $100. DNA testing fee of $60 and a $68 state cost. You do have the ability to seek and appeal this sentence. We're going to provide you with some papers that explain your appellate rights to you, as well as how to request a lawyer to help you with the appeal if you needed that. Counsel, if you could just let me know once Ms. Davis has acknowledged receipt of those.
would I be able to still be in contact with my counselor?
I'm not sure what the jail's rules are on that, so we'll have to talk to them about that. Okay. All right. Mr. Roll, anything further on this file today?
Judge, I may have missed it, but she wasn't at the 7 days credit.
Correct, yeah. Ms. Davis, you are remanded to the custody of the county at this time. Our next hearing set for 9:45, so we'll be in recess until that time. You know, is Mr. Edmond lodged?
He is downstairs.
Yes, okay, we have it there. Do you know about Mr. Logan, whether he's lodged or not? I don't think he's lodged or not.
Mr.
Counsel,
Yes, he
Mulder.
is lodged.
Hey, we're ready for Edmond to appear.
He's in NDOC.
Yeah, I'm not sure which one.
Okay.
If it wasn't raised by.
Okay.
Read them right now.
Oh, perfect. Thank you. Okay, so Mr. Logan's in POC.
Until 2026.
All right, Mr. Edmond, are you able to hear me okay?
Yes, sir, Your Honor. I can hear you just fine.
All right, we're on the record now in People versus case number 205961. The record should reflect Mr. Edmond is present today by video from Otsego County Jail. If I could have counsel put your appearances on.
For the record, Your Honor, my call on behalf of the people.
Good morning, Your Honor. Larry Brown on behalf of Mr. Edmond.
All right, this is set for a status conference today. Mr. Edmond was apprehended in September. There had been an outstanding bench warrant based on a failure to appear back in the summer of 2022. Mr. Brown, have you had a chance to talk to Mr. Edmond?
I did, Your Honor.
Okay, how did we want to proceed today?
I had an opportunity to speak with him, it's like back on the 13th, for some time. There has been a plea offer in this matter to plead to counts 1, 4, and 6. I reviewed those 3 times with Mr. Edmond, specifying the nature of what the plea would be. I'm going to defer to him to see if he is going to take that.
All right, Mr. Edmond, did you want to accept that plea agreement today, or how did you want to go forward?
Just 1 second, Your Honor. Before I was going to get into that, I was going to say, on July 7th, Your Honor, I remember seeing you on my Zoom up on my iPhone. If I'm not mistaken, I remember seeing you on my iPhone and we talked, and you told me that you was going to send something to my mom's address. And I never received that, Your Honor. My mom's address is 1909 West Pasadena, Flint, Michigan 48504. Did you guys send it to the correct address? Because I remember me and you had talked, and you said you was gonna send me something. And I was just I've been in the jail for almost 30 days now, and I was trying to see I'm not saying that you guys had lost any type of documentation, but I was trying to see what was going on, you know.
So are you asking me if I remember something I said to you back in July of 2022?
Your Honor, what he's saying
Yes,
is
sir.
he-
It was actually July 7th. I had saw you on July 7th on my phone, up on my iPhone.
he's saying that he.
And me and you talked on Zoom, Your Honor. And you know, man, I got a 4-year-old daughter. I gotta get back home to her. And I know that I saw you July 7th. And I've been in here for almost 30 days, Your Honor. And you know, I'm basically willing to do anything that you guys need me to do. Like I said, I remember being here. I know this was a jury status conference bond hearing. I've been here, Your Honor, and you know, I know Mr. Larry Brown did want me to plead to counts 1, 4, and 6. And I was almost willing to do it, but it was like the larceny from the building. It's just too much for me, Your Honor. Like, you know, I had a prescription for my Xanax, which is I did not hold it correctly.
Mr. Edmond, we're not gonna try the case right now.
Okay.
I think what your lawyer said, Mr. Edmond, if you make statements here on the record today, they could be used against you later. So I think your lawyer is advising you not to make factual statements about what happened in your case.
Okay, sorry about that, Your Honor. Sorry about that, Mr. Larry Brown.
All right, well, so, you know, what do you think was happening with your case since July of 2022? You got arrested in September of 23. That's 14 months. What did you think? You were just waiting for us to contact you? Is that what you're telling me?
I mean, basically what I was saying, like, I know I probably like checked in on you guys and see what was going on, but like I really was waiting on the mail to come, you know, to see if I had to appear up on another Zoom, because I figure like if you wanted me to see you in person, I wouldn't head it on Zoom today. I would have came upstairs and seen you in person, Mr. Judge Mertz. So
Okay.
I was there.
All right.
And I corroborated. I know I saw you, and I know we talked. I know for sure.
Okay. So do you want to accept the plea agreement today, or do you want to go have the court set this for a trial?
So if I accept the plea agreement today, what would I be looking at, Your Honor? What would be the offer?
I have no idea. All I can tell you is what the plea agreement is and what the maximum possible penalties are for each of the charges.
Okay, what are the maximum charges of the sentence of the charges, Your Honor?
So count 1, which is possession of Xanax, that is a maximum of 2 years and or a $2,000 fine. Count 4, which is larceny in a building, that's a maximum penalty of 4 years and or a $5,000 fine. And count 6, which is possession of a taser, that is a maximum of 4 years and or a $2,000 fine.
Okay, I very much understand
the maximum possible penalties that you could face for each of those charges.
Okay, and okay. So, and I see that my bond has got revoked, Your Honor, and I know I was there. So what about like a bond until I be able to make up my mind to see if I really, really want to plead guilty to these charges?
So you have failed to appear. This was the third time that you failed to appear. Your case has been going on since 2020 because of the various times that you have not appeared in court. So the court is probably going to set a very high bond, probably something like around $100,000 cash or surety, to make sure that you're here so that we can go forward with your case.
Oh, wow.
Because we've spent 3 years with you, kind of off on the run, waiting for us to mail you about your case, and that's not working. So I need to assure that you're going to appear in court when you're supposed to appear in court. And based on what's gone on so far, the only way to do that is either to have a really high bond so that you have a lot of money out there, so that you have a real big incentive to appear in court, or you can't post bond and you're in jail and we know where you're at, so we know you'll appear in court.
So, okay, Your Honor. So July 7th, you don't got that documented that me and you saw each other on Zoom?
All I know is based on my records, you weren't here on July 7th and you've done nothing over the past 14 months to contact the court and find out what's going on with your case. So when that happens, I consider that you've absconded and had no intention, unless you were arrested, in appearing in court.
Okay, Your Honor. So you wanted me
Frankly,
to appear in
that's the only reason why you're here today, is because you got arrested.
I understand that. So you wanted me to appear in person or on Zoom July 7th? Because if it was on Zoom, me and you talked July 7th. So that means that I didn't fail to appear in court if me and you talked on Zoom.
Well, you failed to appear at any point in the last 14 months. And frankly, I don't remember what I told you in a hearing 14 months ago.
Okay, so today, Your Honor, I have to get back to my 4-year-old daughter. I have a family out there that really, really loves me. I have to get back to work. So today, Your Honor, I'm just going to man up and I'm going to plead guilty to those charges. And hopefully it'll be a great outlook on me because, like I said, I have a big responsibility out here in the world. And I'm ready to get this over with, Your Honor. Like I said, this charge is from 3 years ago. I'm ready to just man up and just go on ahead and do what I got to do to get back home to my family and my daughter, Your Honor.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor, that is the truth.
Thank you. Mr. Edmond, are you currently on any kind of probation or parole?
No, sir, Your Honor, I am not on parole or probation.
Okay, you can go ahead and lower your hand. Thank you. Mr. Edmond, again, I'm going to go through the maximum possible penalties for the charges that you're going to plead guilty to today. So again, count 1, which is possession of Xanax, that's a maximum possible penalty of up to 2 years and or a $2,000 fine. Do you understand that?
Yes, Your Honor, I do understand.
And count 4, which is larceny in a building, the maximum possible penalty you could face would be up to 4 years and or a $5,000 fine. Do you understand that?
Yes, sir, Your Honor, I do understand that.
And then finally, count 6, which is possession of a taser. Again, maximum possible penalty of up to 4 years and or a $2,000 fine. Do you understand that?
Yes, sir, Your Honor, I do understand that.
With all of those things in mind, what is your plea to each of those charges today?
I plead guilty, Your Honor.
So I'm going to go through your rights with you. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand that you have all of those rights.
Yes, sir, Your Honor, I do understand that.
And you understand that you're giving up and waiving all of those rights and that you won't have them anymore, and that includes the right to have a trial.
Yes, sir, Your Honor, I do understand that very, very much clear.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask the Court of Appeals to hear your case. You could say no, and then you wouldn't be able to go any further with that appeal. Do you understand that?
Yes, sir, Your Honor, I do understand that.
Has anyone threatened you with anything to get you to plead guilty?
No, sir, Your Honor.
Has anyone promised you anything other than what we've said here in court today?
No, sir, Your Honor, they did not.
Is it your own free choice to enter this plea?
Yes, Your Honor, it is.
Are you pleading guilty because you are guilty of each of these crimes?
Yes, sir, Your Honor.
So the date that I have on this is, like I said, it's been quite a while. We're talking about August of 2020. Were you here in Otsego County back at that time?
Yes, sir, Your Honor, I was.
When you were here in Otsego County at that time, did you have possession of some Xanax?
Yes, sir, Your Honor, I did.
Did you know that that's what that was?
Yes, sir, Your Honor, yes.
Did you have any legal right to have it at that time?
Yes, sir, Your Honor, I did.
Okay, did you have a prescription for it? Is that what you're saying?
Yes, sir, Your Honor, I did.
And the Xanax that you had, was it the Xanax that was prescribed to you, or did it come from somewhere else?
No, sir, Your Honor, it came directly from my doctor.
Okay, so you can't be guilty of illegally possessing Xanax if you had, if you had a prescription for it, if it was your Xanax, so.
Your Honor,
I know. They
If we
told
could
me
ask-
that I had the,
if we could ask him if
They
it was a
told-
valid, an expired prescription.
Okay, what, was it a valid prescription? Was it expired?
well, I don't, no, Your Honor. I just didn't have them up in my bottle. I had them actually in my sock, Your Honor. I didn't have them in my bottle. I didn't carry my bottle with me, when I came down here, with the young ladies that I was with, Your Honor.
Okay, why did you have them in your sock instead of in your pill bottle?
Because of the neighborhood that I live in and stuff, like you can get like robbed and stuff, like what people think that you got something, maybe something that costs a lot of money and stuff like that. So I actually just had them like in like a little sandwich baggie and stuff like that. And I just, you know what I'm saying, take them whenever I have my anxiety. Like you can even call my mother. I have prescriptions for those. I have real high anxiety, Your Honor. And I really, really need those.
Your Honor, perhaps with some assistance, if I may.
Yeah, please.
Mr. Edmonds, back when this occurred back on August 13th of 2020, isn't it correct that in fact you were on probation for possessing a small amount of crack cocaine? Your probation officer at that time was Mark Drake, Drake. Do you recall that, sir?
Yes, I do.
And as a condition of your probation, you were not allowed to use any controlled substances. Specifically, you weren't allowed to possess anyone that were not currently prescribed, correct?
No, Mr. Larry Brown, that is not true. Mr. Mark Drake, he also let me know that, matter of fact, Mr. Larry Brown, I was never even drug tested because that wasn't my thing. Like, I had got accepted into into like drug court, and they even accepted, and that was Mr. Judge Luchana, Your Honor. So no, that's not true at all.
You were taken into the Otsego County Jail, correct, on charges of larceny in a building and larceny on a person and possession of a taser, correct, sir?
Yes, sir.
And that the drugs were found in your sock at the jail, isn't that correct, sir?
Yes, sir.
And you were asked before you came into the jail whether or not you had any controlled substances or any drugs that you had a prescription for. And isn't it true that you told the officer at the jail that you did not have drugs and you did not have any prescriptions for them, but the drugs were in fact found in your sock?
Mr. Larry Brown, when I talked to you this Friday at 7 p.m., Friday the 13th, I told you that the lady officer did not check me. I was under the influence of my medicine at the time. So when I got here and she took all of my money out of my pocket and gave it to the other people that just said
Okay,
that I
again,
didn't take money.
Mr. Edmond, I'm gonna advise you not
No,
to say
sir.
anything further. I don't think we're,
Well, I think we have a factual basis for count 2, frankly. And so, under the court rules, I can take the plea to count 1 using the factual basis.
Correct, Judge, and that's what I was going to suggest, which is why I asked the questions that I did. Thank you.
Do you have any objection to that, Mr. Brown?
I don't.
All right, so Mr. Edmond, let's move on and talk about the larceny charge. So count 4, it alleges that you were at a house and that you took some money from that house. In fact, and that we're talking about the same time frame in August of 2020. Were you at a home here in Otsego County?
Yes, I was, Your Honor.
Okay, and did you take some money from that home?
To be honest, Your Honor, no, I did not. I just want to get this case over with, Your Honor. So I'm pleading guilty. So I'm gonna just say yes, Your Honor. I'm trying to get this out the way. I have a 4-year-old daughter. I have to get back home to her. So whatever my consequences may be, Your Honor, I'm just gonna man up and I'm just gonna take them.
Okay, so I can't take a guilty plea if you're not guilty. And so you're telling me you want to be honest, but then you're also telling me that you want to just plead guilty to something that you didn't do. So I need you to be clear with me. Did you steal some money from a home here in Otsego County in August of 2020 or not? It's very, very simple.
Yes, sir, Your Honor. Yes, sir, Your Honor, I did.
Okay.
Yes.
Did you have any permission from the person that you took that money from to take the money?
No, sir, Your Honor, I did not.
And was it your intent to take that money and use it for yourself, for your own uses?
No, sir.
No? What were you going to do with it?
Yes, sir. Yes, sir. Yes, sir. That was my intent.
All right. At that same time, also here in Otsego County, did you have possession of a taser?
Yes, sir, Your Honor, I did.
Did you have any legal right to have that weapon at that time?
No, sir, Your Honor, I did not.
All right. Mr. Rolla, are the people satisfied with the factual basis?
People are satisfied the court has sufficient factual basis for accepting the defendant's guilty pleas as to counts 1, 4, and 6, as set forth on the record, as complied with the court rule and statute as to acceptance of pleas, and we're aware of no threats, promises, or other inducements not placed on the record.
Mr. Brown.
Thank you, Your Honor. I am also satisfied as to a factual basis, unaware of any promises, threats, or inducements not placed on the record, and the court has complied with statute court rule for taking pleas.
Thank you. Mr. Edmond, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to all 3. We're going to set this matter for a sentencing hearing. You're going to be contacted by somebody from the probation department here. They are going to do a pre-sentence interview with you, and then we'll have that sentencing hearing and go forward from there. The court is going to order that you be held until that sentencing hearing date without bond. Mr. Roll, anything further for today's hearing?
No, Your Honor, except for maybe a housekeeping matter, as far as the bench warrants, now these defendants entered his guilty plea. The court chooses to dismiss the bench warrants, that's fine with people. Or if you want to roll it into sentencing, that's fine as well. I just wanted to indicate that for the court's I'll let the court have the discretion in that regard.
Yeah, thank you. The court's not going to proceed on separate contempt charges. The court will just take failures to appear into consideration of your sentence.
Very good, thank you, Judge.
Mr. Brown?
Nothing further, thank you.
All right, Mr. Edmond, that's all for today. Thank you.
All righty, thank you, Your Honor. Hey, quick question. So would I be getting some paperwork today, Your Honor? About the next court date and things, like how long would I have to wait in here and things, and, you know?
It'll probably be about 30 days.
30 days?
Yes.
All righty, Your Honor.
All right, thank you. Ms. LeBaron here. Bill versus LeBaron, case number 236589. Should reflect Ms. LeBaron's present here in the courtroom. If you could come right up to the podium there, please. I get a counsel put your appearances on.
Record, Your Honor, my Brown Baptist people.
Larry Brown on behalf of Ms. LeBaron.
And Mr. Brown, how did we want to proceed today?
I'm pulling it up, Your Honor. There has been a plea offer made in this matter. I have reviewed it with my client. We plead to count 1 for dismissal of counts 2 and 3. It is my understanding we are going to go forward with that plea today.
Mr. Roll, is that a correct statement of the plea offer?
It is, Judge, thank you.
Ms. Fox LeBaron, have you had a chance to talk to Mr. Brown about this? Go ahead.
Your Honor, I should mention as well, so that the court can bring this up, it appears that she may be on HIDA deferral with Muskegon.
Out of Muskegon, Judge, that's correct.
Okay, so have you had a chance to talk about this with Mr. Brown? Is that how you want to proceed?
Yes.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You understand that the maximum penalty that you could face for this charge, which is possession of cocaine, is up to 4 years and or a $25,000 fine.
Yes, sir.
And have you talked to your probation agent in Muskegon about this plea here today?
I have not.
So you understand that by entering this plea today, that it could be a violation of your probation there?
I do.
And that you could face some penalties there, including losing that HIDA status.
Yes, sir.
With all of those things in mind, what is your plea to this charge here today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. You have the right to testify at a trial yourself if you want it. You understand all of those rights.
I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here today on the record?
No, sir.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes.
This happened on June 28th of this year, is that correct? On that day, were you here in Otsego County? When you were here in Otsego County, at that time, did you have possession of some cocaine? Did you know that that's what that substance was?
Yes.
Did you have any legal right to have it at that time? Thank you. Mr. Roller, are the people satisfied with the factual basis?
People satisfy the court's sufficient factual basis to accept the defendant's guilty pleas to count 1 as complied with court rule statute as to acceptance of pleas, or where no such promises or inducements not placed on the record.
Thank you, Mr. Brown.
I'm also satisfied as to the factual basis. I am unaware of any promises, threats, or inducements not on the record, and the court has complied with statute, court rule for taking pleas.
Ms. Fox LeBaron, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Brown prior to that date. And then you're going to meet with Mr. DeLeo before you report here today, okay?
All right. Thank you, Your Honor.
It's like MDOC never connected with Mr. Logan, so I'm gonna take a break. Can you just ask Suzie to check with information?
Oh, yep. Thank you.
We'll see if we can get a hold of Mr. Logan. Otherwise, our next hearing set for 10:30. I had your attorney signed in and then he just disappeared. So, that's, I'll have you just wait for a couple more minutes.
Okay.
Don't touch anything. When you're done, just let the officer know on the other side, okay?
Yep. Sir, is your name Mr. Logan?
Yes, sir.
Okay, all right. On the record in People versus Christopher Logan, case number 236582. The record should reflect Mr. Logan's present today by video from Department of Corrections. If I could have counsel put your appearances on.
Thank you, Honor. For the record, Michael, on behalf of the people,
On behalf of Mr. Logan,
All right, this is set for a status conference today. It looks like this is Mr. Logan's first appearance before circuit court. Mr. Brown, can you tell me where we're at with this file?
Yes, Your Honor, there has been an offer made in this matter. I believe it is lead to count two. I think it's an habitual second or dismissal of the remainder, but I will verify that with Mr. Logan.
Judge, plea to count 2 with the drug double, joint civil restitution, $350 with other co-defendants, as to saying count 1 would then be dismissed. Correct, Judge.
All right, Mr. Logan, were you able to hear that?
Yes, sir.
Okay, did you want to go forward with that plea today?
Yes, sir.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you. You can lower your hand. Mr. Logan, are you currently on some type of parole or probation?
I'm serving prison time right now. I got 3 years left.
Okay, so were you on parole or anything at the time that these charges in this case happened?
I was on bond.
Okay. You understand that the maximum penalty you could face, did we say count 1?
Count 2, Judge, is
two.
a drug.
Okay. The maximum possible penalty you could face for count 2, which is delivery or manufacture of heroin, as a second or subsequent offense, that the maximum penalty you could face would be up to 40 years and or a $50,000 fine. Do you understand that?
Yes, sir.
With that maximum possible penalty in mind, what is your plea to that charge today?
Plead guilty.
So right now, I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
I do.
Also, you don't have an automatic right to appeal the plea that you're making today. If you wanted to try to appeal it, you would have to ask the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here on the record today?
No, sir.
Is it your own free choice to plead guilty?
Yes, it is.
Are you pleading guilty because you are guilty?
Yes, sir.
So the date that I have on this incident is June 7th of 2022. Does that sound like the right time frame?
What was the date?
June 7th of 2022.
Yeah, it sounds right.
Okay. Back at that time, were you here in Otsego County?
Yes, it was.
While you were here in Otsego County, did you have possession of some heroin?
Yes.
Did you give or sell that substance to another person?
Yes.
Did you have any legal right to do that at the time?
I'm sorry, what?
Did you have any legal right to give or sell that substance to another person at that time?
No, sir.
Okay. And had you previously been convicted in the state of Minnesota back in January of 2019 of possession of methamphetamine?
It was acid, but I think it was classified as methamphetamine.
Okay, but you did have that previous conviction for possession of that substance?
I'm sorry, you're kind of lagging.
Sure. You did have a conviction for possession of a controlled substance in Minnesota in January of 2019 though?
Yes.
Okay. Mr. Rolla, are the people satisfied with the factual basis?
Yes, Judge.
Mr. Brown?
Yes, Your Honor, and I am not aware of any promises, threats, or inducements not on the record. The court has complied as well with statute court rule.
Would concur, Your Honor, the court comply with statute and court rule as to acceptance of plea with we are also aware of no threats, promises, or other inducements not placed on there.
Thank you. Mr. Logan, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Mr. Logan, you do have the right to have that hearing in person here in the courtroom in Otsego County. If you wanted to exercise that right, the court would sign an order to have you transported here for that hearing. You can also waive that right and we can have that by video. Do you know how you'd like to proceed in that regard?
Through video is fine. I don't need to be there.
Okay, so the court will set it for a sentencing hearing by Zoom, but somebody from probation and parole will be in touch with you for a pre-sentence report prior to that hearing date. Mr. Rolla, anything further we need to address on this case?
No, Your Honor, thank you.
Mr. Brown?
Nothing further, thank you.
Mr. Logan, did you have any questions at all?
No, sir. Thank you.
Okay, all right, thank you. That's all for today, and the court's going to disconnect at this time.
All right, thank you.
Your Honor, I believe that is my morning docket.
Yes, thank you. All right, Mr. Truce, are you able to hear me okay?
Yes, Your Honor.
Okay, Mr. Hurd, if you would come back up, please. We'll go on the record in People versus Jeffrey Hurd, case number 236607. The record should reflect Mr. Hurd is present here in the courtroom today. If I could have counsel put your appearances on.
Again, for the record, Your Honor, Mike Cronenberg.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Hurd.
Okay, Mr. Truce, how did we want to proceed with this case today?
Thank you, Your Honor. This is our first hearing up in circuit court. This is a pretty complicated case. I've got a lot of witnesses still to get through an interview. So I'd be asking the court to consider setting it out about 90 days. I think at that point, we'd likely be in a spot where we're prepared to either ask the court to docket a trial or have had an opportunity to go through all the other options.
Mr. Rolla, any objection to that?
No, Judge, and I would indicate there has been an offer extended to the defense indicating an offer of plea to either count 1 or count 2, the dismissal of the other count as well as the habitual fourth enhancement.
Mr. Hurd, have you had a chance to talk to Mr. Truce about this delay of about 90 days?
Yes, I spoke with it.
Do you have any objection to that?
No, Your Honor.
Okay. All right, I think given the nature of the charges here, I think some time would be appropriate to allow the defense to fully investigate the charges and to consider any potential plea offers. But Mr. Truce, once we're back at that 90-day mark, the court will set that as a plea cutoff. I think at that point, we'll need to either have a resolution or set it for trial.
Understood, and we expected that, Your Honor.
Okay, so Mr. Hurd, just make sure that you stay in touch with Mr. Truce over the next 3 months. And then when we're back, the court will just need you to have made a decision about whether you want to proceed to trial or accept any plea offers, okay?
Okay.
Mr. Roll, anything further for today?
Not this matter, thank you.
Mr. Truce, anything further?
No, Your Honor, thank you.
Mr. Hurd, did you have any questions?
No.
Thank you, that's all. Is Mr. Thomas present here in the courtroom? Court will go on the record in People versus Jesse Thomas, case number 236608. That matter was set for hearing at 10:30. It's now 10:37. You had any contact with Mr. Thomas, Mr. Truce?
I have, Your Honor. I spoke to him probably about a week ago, and I've had a little bit of email correspondence with him since that phone call. I'm frankly surprised he's not here.
All right, the court will set this for show cause hearing at its next date. If Mr. Thomas doesn't appear at that hearing, the court will issue a bench warrant. Mr. Rolla, any objection to that?
No, Judge, thank you.
Mr. Truce, any objection to proceeding that way on Mr. Thomas's case?
No, Your Honor, thank you.
Right, and then our next hearing set for 10:45, that's Mr. Handrich's case. So Mr. Truce, if you can just stay connected, we're gonna have him brought up to the courtroom here, okay?
May I ask, is the court going to address any matters in between? Because Judge Hunter has one he wants me for right now.
No, the 10:45 with Mr. Handrich is my next case on my docket.
Okay, then I will wait to take care of that.
Great. Thank you. I'm just gonna go off the record for just a couple minutes. Okay, we're on the record in People versus Jeremiah Handrich, case number 236549. The record should reflect Mr. Handrich is present here in the courtroom today. If I could have both counsel put your appearances on.
The record, Your Honor, Michael, on behalf of the people.
Thank you, Your Honor. Richard Church appearing on behalf of Mr. Handrich.
All right, this is the date and time set for sentencing hearing in this matter. Mr. Handrich, if you had a chance to go through the pre-sentence report and talk to Mr. Church about that.
Yes, good to go.
Mr. Church, are there any additions, deletions, or corrections to the report?
No, Your Honor.
All right, and I know, Mr. Roll, I know that you've got a challenge to the scoring of OB4, but Mr. Trush, are there any challenges to the scoring from your side?
No, Your Honor.
Okay, and before we get to the challenge, Mr. Roll, are there any additions, deletions, or corrections?
No additions, deletions, or corrections. However, I would advise the court that we've been contacted by the victim and they're on their way.
Okay, so do we?
Oh, I'm sorry, they are here now.
Okay, all right, so we don't need to wait at this.
No, Judge.
Okay.
I was just advised a few minutes ago they were on their way. Apparently they arrived in that interval.
Okay, and then I received your challenge to OB4. Was there anything that you wanted to state for the record other than what's in here?
Judge, the case law that I believe is very, very clear, specifically looking at the case of People versus Earl, where we had the same scenario where the victim's impact statement indicates that they had sleepless and nightmares. In this case, the victim's impact statement is indicating he's still having nightmares. Very rarely do you get a four corners kind of situation dealing with OB4, and in that case, the points were scored as 10 points as requested by
Mr. Trush?
So, Your Honor, I guess I would indicate, I never received a written victim's impact statement. The only thing that I have is what's contained here in the PSI. And it sounds like the victim may be present in the courtroom. I guess there's no indication that he sought any sort of counseling or treatment for it. And while that's not required, again, I mean, just a mere statement that there's nightmares and nothing else, I don't think is sufficient, especially when that statement isn't even contained in the victim's impact statement. It's just part of the PSIR.
Mr. Rowland, does the victim wish to address the court prior to sentencing?
I believe he does, and Judge, I would indicate the victim's impact statement was put in the PSIR, just like with the case that I cited, People versus Earl.
Yeah, I think, Mr. Trush, you're just referring to the fact that there isn't a separate attached statement as part of the PSI, correct?
That is correct. And I mean, I suspect that he's going to make a statement right now, and I would ask the court to take that as his statement, not the impact statement that's purported to be from him in the PSIR.
All right, so I think before ruling on the challenge, Mr. Rowland, it makes sense to hear from the victim.
And I have no problem with that, Judge, but again, with all due respect, I disagree with defense counsel's assessment that it has to be taken in separate from that or in place of. I think the court is required to take both into consideration for sentencing, whether it's a written impact statement, verbal impact statement, both are being read by somebody else.
Yeah, I agree.
Rights Act.
I agree. Yeah.
Very good.
Okay, Mr. Handrich, if you could have a seat just at that table over there, and then Mr. Roll, whoever it is that would like to come up and make a statement here. Right up to the podium here, sir. Yes, sir. Can you tell me your name, please?
William Loftus.
Can you just state your last name again so it's clear for the record?
Loftus, Loftis.
So, and Mr. Loftus, you were the one that was the victim of this case.
Yes.
What is it that you would like to state to the court here today prior to sentencing?
Well, I'd like to let the court know that he was a coward, that he attacked me from behind while I was sitting down in a chair at a bonfire after I'd already been drinking all day. I've had nightmares from it. I have trouble sleeping. I developed a bad drinking habit, but now I kind of fixed that out. Now I'm back to work. I was off work 2.5 months after the incident happened. I just want him to get every minute in jail he can get.
So when you say you were off work for 2 months, was it as a result of
that? Yeah, I was supposed to go back to work the Tuesday after Memorial Day. I didn't end up going back to work till the middle of July because I had to get cleared by the doctors. I have a crack underneath my eye here. My eye's still a little black. I have a crack across the bridge of my nose. Like I said, I've had trouble sleeping. I have nightmares. I can sleep like maybe 2 or 3 hours at a time. Being a truck driver, that's not good for me, not being able to sleep. So I've been trying to take like melatonin stuff without any heavy sleeping pills. But other than that, I mean, I'm back to work now and everything's, better. But I miss time with my daughter because of it. I miss time for work because of it. And I make substantial amounts of money. So when I say I miss work for 2 months, you're looking at almost $20,000 that I can make in that amount of time. So.
Thank you.
Yep.
Anything else that you wanted to say?
No, just I hope he gets every minute he can. Thank you.
Truth would be nice. Truth would be nice.
True.
Truth would be nice, but
Right. We're not gonna have a debate between you guys here.
he's full of shit.
You're gonna have a chance to tell me what you want to tell me.
Sorry, Mertz, he's full of shit, nice.
Again, you'll have a chance.
Sorry.
Wait your turn. We do things very orderly here. All right, Mr. Rowland, anything that you wanted to state for allocution?
Yes, sir, Judge. Now, I understand I put this in my sentencing memorandum. It didn't go specifically to OV4. The course now is going to address that. But there are items as indicated that OVs and the PRVs can't take into consideration. As I indicated under paragraph 3 of my sentencing memorandum, defendant's police report, PSR, under the description of the offense narrative, not only was defendant's assault on the victim brutal, but for the intervention of a third party, we could have been dealing with, quite frankly, fatality, because that's the person who prevented the defendant from getting a knife to effectively, the defendant, in his own words, give the victim exactly he got what he deserved, and if given the opportunity, I would do it again. It's very clear that this particular defendant cannot control his own violent behavior. He is a predator, and if not incarcerated for an extended period of time, he will continue to present a danger to this community, this society, which is why we asked for the increase in scoring on OV4, which of course then, if granted by the court, as the people believe it should be, is going to change his level. OV score would then be 50 points, not 40 points, raising the defendant's level to a level 5 from a level 4. They changed the scoring range from a minimum of 34 to 134 months up to 38 to 152 months. And we'd ask that the court take that into consideration and sentence the defendant accordingly. Thank you, Your Honor.
All right, so I did have a chance to review the case law cited by the prosecutor as to the scoring issue, as well as OV4 and the statute that governs the scoring of that variable. It does allow for the scoring of 10 points where there's sufficient psychological injury that may require treatment, that required that the person seek treatment. Looking particularly at People versus Earl, which I did read, and it is, I agree with the prosecutor, it is on point with the case here. Mr. Loftus provided the victim impact statement prior to the hearing, which indicated that he suffered some psychological injury as a result of this in terms of being able to sleep at night. And under People versus Earl, that I think it's pretty squarely on that is scoreable as 10 points under OV4, even if he hasn't sought any actual psychological treatment. So the court finds that under a preponderance standard, there is sufficient evidence to support a scoring of OV4 at 10. And so then that does adjust the guidelines as indicated by the prosecutor, and the court will order that the SIR be amended to reflect that scoring. In terms of variables or any other statements from your side, Mr. Rolla, is there anything further?
No, Judge.
All right, thank you. Mr. Handrich, if you want to come back up to the podium. Mr. Trush, is there anything that you wanted to say on behalf of Mr. Handrich?
I do just want to speak very briefly. You know, Your Judge, Mr. Handrich has not made any excuses for what happened. He's come forward. He was honest about the assault and what occurred there. He makes no bones about that it was a serious assault. I mean, there's no excuses there. He recognizes that he's looking at a long term of incarceration. And frankly, going into the plea agreement, knew that. Our position all along has been that There was not any intent here to commit a murder. That's not what occurred. Yes, there are some statements by Mr. Handrich in the heat of the moment that are hyperbole. But the fact of the matter is, the plea agreement that we entered here, we entered into an agreement with a sentencing agreement to the top end of the guidelines. In exchange for that, there was the reduction that was made. Again, Mr. Handrich accepts what he did, and we would just ask the court to follow that agreement.
Thank you, Mr. Handrich. What is it that you would like to say today?
All right, sir, I'm gonna tell you the truth, okay? We were at a bonfire. We weren't very intoxicated, okay? Bill gets pretty cocky when he's drunk, all right? Went in the house, grabbed some weed to smoke with him. He had a pocket knife on him, a little box cutter. And about a week before this incident happened, I had some weed come up missing, and I blamed him for it. Well, I found it later on in a sweatshirt pocket that I drooped over a chair in the living room, well, in the kitchen, dining room, whatever you call it. And I went out at that night and apologized to him for it. I said, listen, man, I'm really sorry. You deserve my apology. I'll give you the weed that I thought was stolen out of respect, so whatever. No big deal. So we get drinking and whatever. And I was like, well, you know, what would you really do if I would attack you for stealing from me? You know what I'm saying? He's saying, well, I'll pull my knife on you. I'm like, oh, how's that? How you can do that? And I was like, show me how fast you can draw it. We were drunk. I was being cocky to him. I was being a jerk. Pulls it up and he hits me. He gets me right here and cuts my lip right here with it. I'm like, hey, dude, I'm just playing around, man. You gotta take this serious. He's like, oh, go home, still. He starts rubbing my face all queer like. So I said, dude, get away from me. We don't do that where I'm from. That's disrespectful. Do it again, we're gonna have a problem. He's all drunk, comes up again, touches me all queer like again. This time I lay him out on the ground, punch him right in the face, knock him out cold. A wave came over me in anger. He starts getting back up. So I just went over there and started beating on him. I kicked him in the face like 3 times and punched the hell out of him until I was done. Figured he got what he deserved. Went in the house, told his girlfriend Ellis. I said, listen, man, I think I killed your boyfriend outside. You might want to go check on him. Yes, I was looking for a knife after it happened, but I didn't go outside with it. And I didn't even go on through with what I planned on doing. I was just going to leave. I was going to cut my tether off and leave. But instead, I sat in the house, went to bed, and said, I'll see what happens tomorrow. That's when the cops show up with the guns. I hear, Mr. Handrich, you're under arrest, da-da-da. Totally coherent about it. I was totally respectful about it. Was mad. Went to jail. Here I sit. Meantime, he wants to make a bunch of stories up because while I was in here, either him or his old lady stole all my stuff. I do appreciate giving my weights back to my father. But along with everything else, they kept. So of course they're going to make statements that are going to try to get me locked up as long as they can. Shoot, I wouldn't say I wouldn't, but sure don't approve of it. So again, I'm going to say you're full of shit. That's all I got to say, sir.
All right, well, I read through the report. So I take all of that information into consideration in sentencing. As you know, as part of the plea agreement, the sentence was already kind of set. The only question is, what are the guidelines going to be? There's a lot of information in that report about you, your circumstances, your background and history. So I take all that into consideration along with what you've had to say here today. I listen to what the lawyers have to say. I take that into consideration, and certainly the victim, Mr. Lawless, I appreciate you coming in and making a statement here today. It's always important for the court to hear from victims, particularly a violent crime like this where there's significant injuries. It's important for the court and the public to understand the impact that this has had on you, Mr. Loftus, and your family. So I certainly appreciate statements that were made. And I think in general, it's a good thing for victims to come forward and talk about what happened to them. It's not an easy thing to do. I think it's a good example for other people who are victims of crimes. You know, frankly, I don't think how this started or what brought it on really is that relevant here. I mean, you beat up somebody pretty seriously for something that really isn't that big of a deal. You didn't have to do that. You could have just been like, hey, don't touch me. You could have walked away. You could have just been like, yeah, I don't like this, but it's not worth almost killing somebody over.
Understand
that. I mean,
understand I have anger issues.
Yeah,
that's why I seclude myself from the public. I don't hang out with nobody. I lift weights and work. That's all I do. Yeah, that's all I do. That's all I've ever done.
And that's, yeah, I agree. I think you have anger issues. Taking everything into consideration, I think the agreement is appropriate. I think a sentence at the high end of the guidelines accounts for both your past history and tendency to commit these kind of crimes. I think it addresses the injuries that were inflicted on the victim in this case. And I think it's appropriate and reasonable. So the court is going to follow that recommendation that the parties have made. Based on the guidelines, then what we end up with is a sentence of 152 months. Because this is a life offense, the court is required to set an upward limit. So the court is going to set the sentence at 152 months to 40 years. Because of your status on parole, you're not entitled to any jail credit. And the sentence is to be served consecutive to any sentence that you receive for violating parole. Crime victim's assessment of $130, court costs of $325, attorney fees of $350, state costs of $68. You have the ability to appeal this sentence, and we're going to provide. We'll do this down in the jail. If you want to take the papers down,
Yes.
Mr. Handrich, and Mr. Handrich, once you're back down to jail, we're going to have you just initial these to show that you received them, that they explain to you what your appellate rights are, as well as how to request support for lawyer.
Thanks.
Mr. Roll, anything further for the record here today?
No, Your Honor, thank you.
Mr. Trush,
No, Your Honor, thank you.
Mr. Handrich, you are remanded to the custody of the state at this time.
Yeah, you get yours, bud. Just believe it. It'll come.
Mr. Rolla, to the extent that you want to take those last statements of Mr. Handrich into consideration with regards to any future action, you're on the record, you're obviously.
Thank you, guys.
Our next matter is with Mr. Bonamy. Mr. Trush, I think that was your final matter for the day. Our next matter is at 11 o'clock with Mr. Bonamy. He's lodged, so I think we're going to get him on polycom. So you can just let me know when their jail's ready.
Yeah, I'll call right now.
They need a minute. I got it.
Yeah.
Just a second. That's fine. All right, Mr. Bonamy, are you able to hear me okay?
Yes, sir.
Okay, we're on the record in Hill versus Bonamy, case number 216097. Mr. Bonamy is present today by video from the Otsego County Jail. And we have Mr. Rolla and Mr. DeLeo here on behalf of people in probation. And Mr. Bonamy, I'm just looking at the notes here. You requested a court-appointed attorney, and it looks like you were screened, but we're not eligible. How did you want to proceed in terms of your representation?
Sir, I don't really know. I've been writing you letters. They just handed them back to me. I asked for this to be closed court because there's people in danger right now, and I have information on it. I've been writing you letters. The jail has not been delivering them to you. They just handed them all back to me. But I request this to be a closed court. I mean, if I have to, I'll represent myself. But I request that it go off of being live streamed, and I will read the letters to you.
I mean, I don't want you to read letters to me. I don't think that's probably not appropriate. I mean, I don't know why the jail didn't deliver them. But I don't know if it was a timing. Yeah, I don't know if it was a timing thing or not, but you know, our proceedings are required to be open to the public, so I can't just close the court. It's just not, you know, I'm required to keep everything open to the public, and anybody who wants to come in can do it. So
There is people's lives in danger.
yeah, I understand, but just from you saying that to me, I can't just close the court. I mean, having open public court proceedings is a pretty important thing. So I'm sorry, I can't just not do it. If you want to try and send me those letters, I'd be happy to take a look at them, particularly because you aren't represented in this case. And Mr. Rolla, of course, the court would copy those to your office as well, because Mr. Rolla has the right to see anything that I'm seeing, or the probation department for that matter. So, you know, in terms of a lawyer, did you want to see if do you want to try to hire your own attorney to represent you? I mean, how do you want to proceed on that?
I would like to. I haven't. I was supposed to go to treatment last week, but the jail won't let me even speak with treatment unless you order it. So I could not do my intake to go to treatment. I even have the money to bail myself out, but I have no one. I'd have to be able to send it to my mother, and the jail will not allow that as well. So I really don't know what to do here. I'm a little lost. I have no advocates on the outside. I've been waiting to speak with I don't know what to say, sir.
Mr. DeLeo, do you think any light you could shed on this for me?
Well, there is a plea offer, Your Honor. I don't think Mr. Bonamy is aware of that, but if he wants to plead guilty to counts 1 and 2 of the technical probation violations, then count 3 and count 1 of the non-technical would be dismissed.
Okay. Were you able to hear that, Mr. Bonamy?
Yes, I don't know what any of those are even, to be honest with you, sir. Like I would if you were to read this letter, you would understand more where I'm at. I can't. I honestly don't. These letters are crucial and like they're vital.
All right, so are you asking me to adjourn this hearing today so you can get those to me and I can look at them and then have this reset? Is that what you want to do?
Yeah, yes, sir. And I would urge you to try to read them sooner than later.
Mr. DeLeo, do you have any objection to that?
I don't.
I mean, we can set this for in another 2 weeks, and maybe if you can communicate, so Ms. Davis, or have Ms. Davis communicate the options to Mr. Bonamy.
I will, Your Honor.
Okay, so Mr. Bonamy, Ms. Davis, who's your agent, she's going to contact you and discuss how to proceed with these violations. If you do want to hire your own counsel, obviously you're free to do that. Unfortunately, it sounds like you're not going to qualify for a court-appointed attorney. I'll tell the jail that you know, to get me those letters, and then we'll have this set for another hearing date as soon as possible. Okay.
All right. Thank you, sir.
Okay, all right, thank you. That's all for this hearing today, and the court's going to disconnect this time. Mr. Guinea, if you want to come up to the podium, please. We'll go on the record in People versus Keith Guinea, case number 226273. The record should reflect Mr. Guinea's present here in the courtroom today. If I could have counsel put your appearances on.
Thank you, Your Honor. Director, my fellow people.
Good morning, Mike Mataloni on behalf of Mr. Guinea, who's standing to my left.
So I am in receipt of the pre-sentence report. I did get a victim's impact statement. Mr. Logan had a chance to review that. Mr. Mataloni, I also received a number of letters on behalf of Mr. Guinea that I had a chance to review prior to the hearing today. Mr. Guinea, have you had a chance to go through the pre-sentence report and talk to Mr. Mataloni about that? Mr. Mataloni, are there any additions, deletions, or corrections that need to be made to the report?
Under time served, I think he has 56 days as of today.
Mr. Rolla?
Judge, it is whatever it is.
So we'll amend that to reflect 56 days of credit. Any other corrections?
He wants more time to read over the PSI. I'll just sit with him here, I guess.
Yeah, I mean, I'll give you 5 or 10 minutes. Mr. Guinea.
All right, thanks.
You can sit right at council table. Okay, we're back on the record. Mr. Mataloni, are there any other corrections to the PSI?
None that we have found, and there are a couple of different places where it says 29 days.
Okay, so the court will order that the PSI be amended to reflect 56 days of credit wherever it's applicable. No other corrections. Are there any challenges to the scoring of the guidelines?
No, sir.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections as to the body of the report and challenges as to the scoring guidelines. Thank you, Judge.
Do you have any victims that wish to address the court today?
We do not, Judge, but as the court's already taken notice of, she did provide a victim impact statement.
Anything you'd like to say on behalf of the people for allocution?
Yes, Judge, thank you. Judge, this is a situation where tragically, it's a criminal sexual assault on a younger sister over a period of years by the defendant since the victim turned 12 years of age. As this court's very aware, it's very often criminal sexual assault behavior is learned behavior. Very often, a majority of sexual offenders are often found to have been victims themselves of sexual assault when they were minors. This is particularly problematic for society when the offenses occur within families and or with their relatives, as in many instances, it goes beyond reported due to the embarrassment and or pressure put on the victims not to report them. A minor criminal sexual assault victim feels at fault, at no fault of their own, that it was somehow the circumstances in the instant case that caused it to occur, that other family members of the defendant and the victim themselves put pressure on victims to either not tell anyone originally or even after disclosure to try and get them to recant. As our office was warned about in this particular case, because back on June 8, 2023, our office specifically received notice that members of the victim's family were trying to encourage the victim to recant and literally commit perjury. They had to get notice, was given then to defense counsel that either stopped and ceased immediately, or our office would have been issuing 10-year felony charges for witness intimidation contrary to MCL 751-227. This is unfortunately why this court is aware that CSC and family members can go on for generations on multiple victims without ever being reported. This defendant is a repeat sexual offender. As count 5, item number 5 in the guidelines are, as to count 5, the guidelines in this case are 108 to 180 months to life with the tail of 50 years. As for count 4, 71 months to 15 years, both with then 29 days credit. I understand now that's been corrected to indicate 56 days, which the people did not object. It's the people's hope that by imposing those sentences, that this court will not only protect society from people like this particular defendant, but that for the defendant, now that he's admitted his acts in open court and has been sentenced on that he will receive hopefully likely overdue counseling regarding his behavior, and also that his family members will stop living in denial and keep on blaming the victim. Thank you, Your Honor.
Mr. Mataloni, anything on behalf of Mr. Guinea?
Yes, sir. Just listening to the prosecutor articulate what this family went through. My client's also a victim. And he recognizes that. And he also has recognized, at least to me, that he has not altered his behavior, but instead perpetuated it. But he doesn't plan on doing that any longer. But he is a victim, whether anybody likes it or not, doesn't matter. He was also abused. No one helped him. That caused it to continue to perpetuate. Never having been sexually abused myself, I don't know what that's like. I don't know what that does to a person. But I know he has a bright future, and I know he's a good, decent young man. And I know he made some mistakes. I'm just asking the court not to throw the book at him for those mistakes, understanding that he is also a victim. I'm also asking the court to look at the low end of the guidelines. I think that 9 years is enough years for him to receive therapy and counseling within the Department of Corrections, which they will offer him. I've told him you need to really pay attention to that stuff and get your head around, because when you get out, you got to live your life different. You have to change your way of thinking. And he agrees, and he is already on that road, and pointed out to me that for the last 2 years, he has started to live a normal life. Then these allegations from past came up, and he has entered a plea to them, and he is going to take his punishment for it. But he already knows that it's wrong, and he doesn't plan on perpetuating it. And my client never tried to tell the victim not to say anything. It wasn't him, it was other family members. And I did call them and I did say stop, and they did. And so no one else was charged, but I'm not trying to put that on him. Just like I didn't know he was going to go to jail that day when he pled, he didn't know either. But he understands. And I'm not asking for sympathy. I'm not asking for the court to take any particular position on it other than a reasonable one. That 9 years will be enough. He'll have to be on the sex registry list, and he has to put his life back together without a family. He's going to be alone if he wants to keep his head on straight. Because I myself have received a lot of phone calls telling me that I should not have let him plead, that he should have gone to trial. But I don't agree. I gave my client very good advice, and I think that he took it. And I'm asking the court to run the charges concurrently, the sentence for the charges concurrently, and at the low end of the guidelines. Thank you.
All right. Mr. Guinea, anything that you wanted to say?
I'm sorry for everything that has happened and for everyone's time being here today.
All right, well, I read through the report. I'm familiar with the circumstances that bring you before the court here today. There's also a lot of information in that report about your background and your history and circumstances as well. I certainly take all of that into account, along with what prosecutors had to say. As I indicated at the beginning, I read the statement that the victim provided. I've also received a number of letters from family members from your side as well. And looking at the circumstances as a whole, it is unfortunate, you know, if you've been a victim yourself, it's unfortunate that you then victimized someone else, perpetuated that, as Mr. Malloy indicated. That's not particularly surprising, and unfortunately that does happen in a lot of cases. And hopefully going forward, you're going to get the kind of help and treatment that you need to address that problem and to not victimize more people in the future, understanding the effect that it's had on you. I also, you know, a lot of the letters seem to want me to make some kind of different factual finding or do some investigating or somehow find that you're not guilty of this crime. That's not my role as a judge at sentencing. You've already admitted to the crime. So in the view of the law and the view of the court, you're guilty. And the time for contesting this is over now. And I think to the extent that both the victim, yourself, and the family can accept that fact and move on from it, as opposed to, as Mr. Manalone indicated, living in denial, better everybody's going to be going forward. But looking at your behavior in this case, looking at the conduct that you engaged in, the harm that it caused the victim, as well as your own circumstances and the mitigating factors that are reflected in that, I think a sentence, particularly with regard to the first-degree criminal sexual conduct charge, which is count 5, the sentence which is recommended is 144 months. That's in the middle of the guidelines, and I think it's a reasonable sentence. I think it accounts for your behavior in this case, but I also think that it recognizes some of the mitigating factors and is not a sentence at the top end of the guidelines. So I do find the recommendations overall to be appropriate. The court is going to sentence you as to count 5 to 144 months to 50 years in the Michigan Department of Corrections. You have credit for 56 days served. Court will order that you comply with the Michigan Sex Offender Registration Act as required by statute. As to count 5, a $68 state cost in electronic monitoring. As to count 4, which is the second degree, 71 months to 15 years in the Michigan Department of Corrections with credit for 56 days served. That sentence to be served concurrent to the sentence in count 5. A crime victim's assessment of $130, court cost of $325, and a state cost of $68. You have the ability to seek an appeal of this sentence, and Mr. Manalone, if you would have your client acknowledge to exceed those appellate rates, let me know once he's done.
Yes, sir. We acknowledge receipt of the appellate right form and returning signed copies to the court.
Thank you, Mr. Roll. Anything further we can address in the record? Mr. Madelon.
No, sir.
Okay, Mr. Guinea, you are remanded to the custody of the state at this time. This concludes the court's morning docket. Court will be in recess until 1:30.